Hi, I'm Indiana personal injury attorney David Holub. Last week, a caller said, I was driving down a country road in late summer and was involved in a motor vehicle crash where the other party ran a stop sign, but the other driver says it's not his fault because vegetation was growing into the roadway and covering a stop sign. What is the responsibility of a property owner who lets vegetation grow to cover a sign or block the roadway? We often find that crashes involve an issue with trees, brush, agricultural crops, and the like, blocking a view at an intersection or blocking a view of a sign. The law in general is that to the extent a landowner owes a duty to travelers on an adjacent roadway, that duty is limited to refraining from creating hazardous conditions that encroach upon the roadway. Where the vegetation is wholly contained on a landowner's property and does not enter or extend into the highway right-of-way, there is no duty owed by a property owner to the traveling public. But things get tricky when a landowner voluntarily assumes a duty to mow or remove vegetation near a roadway. For example, suppose the landowner keeps a ditch along his or her property trimmed short and for years mows the drainage ditch once every couple of weeks. You guessed it, by assuming a duty which motorists come to depend upon, a landowner may make him or herself liable if they later choose to abandon that assumed duty and let the vegetation grow, and it blocks a roadway and causes a crash. The same can apply if a farmer sprays a fence row next to a roadway for weeds every year and then stops and lets the brush grow up high and block the view of motorists. Assumed duty cases are difficult to prove, but it can be done if the facts are right, and such cases require extensive investigation and make seeing an attorney soon after a crash very important. If you want to find out more information about personal injury law, we ask you to subscribe to our podcast called Personal Injury Primer.